chatbots and trademark licenses, because I get the impression that sometimes clients and companies using chatbots are kind of running around. They don't necessarily always dot the I's and cross the T's beforehand. They just see something there, or somebody comes to a company that does this and say, hey, this is cool, or I have an idea. You don't necessarily have any clue where the customer got this idea. How does licensing work? Well, license is simply permission to use. In the legal sense, that's all a license means. Trademark licenses can be written or oral. Trademark licenses can be express or implied. That is, you can get an express agreement from the trademark holder, either in writing or verbally. But yes, you can use it. Implied can arise where they kind of know that you're doing it, or they're aware of it, and they're sort of tolerating it, or they're letting it go. Implied licenses like that are typically revocable at will. Right? So that means if you, and that is even though you may put out substantial effort and money in reliance on this person's continuing forbearance, continuing tolerance of what you're doing. It's an interesting issue in Second Life. I do a lot of work relating to virtual worlds in Second Life, where a lot of users, and my point in this example is it's a great example of implied license being revoked. There's a lot of sort of fan use or vendor use of Second Life marks, right? And people build up substantial businesses around their understanding and actual sometimes communication with Linden research that, yeah, it's okay for you to do this or that or the other thing with our marks. Then one day, Linden puts up on their website a whole new set of trademark use guidelines, and people were thrown into turmoil and had to change domain names and do a lot of rebranding. And I was asked by a few people, do I have rights here? And for the most part, these things are revocable at will. So you really, if you're running around using a mark or providing a product or services to a client, and you haven't nailed that down, everybody involved should realize that permission that you think you have or you're assuming you have can be taken away, despite whatever reliance you have undertaken. And so obviously the best practice is to have an agreement in writing, a written trademark license. If they're well represented on the other side, it's going to have guidelines on what you can and can't do, how long you're going to be able to have that license, what scope of use you're going to have for that thing, and other issues, and any money they're charging for it. So I wanted to. What am I doing with time, Richard? 2 more minutes. Okay. Few words then, very few words then, on chatbots and social media. I'm not, chatbots can be deployed in a social media application, obviously by the platform owner itself, the users or subscribers, and third parties external to the platform. I would just say, 100,000-foot view. My thoughts on this from a legal standpoint. First place you should start in protecting yourself is looking at the terms of service governing the platform or the application. What does Facebook's terms of service say about what bots can or can't do within the application, or Twitter? I would just say improper use of chatbots in the social media context can give rise to liability under a number of theories. Breach of contract, that is with the platform owner, consumer fraud or fraud, tortious interference, that means that you're interfering with somebody else's use and enjoyment of the platform, Computer Fraud and Abuse Act, that's a federal statute, and other arcane and exotic things like trespass to chattels and other things from medieval times that we lawyers still like to talk about. A lot of this stuff is intuitive. I mean, if you are using a bot to extract information or deceive people, expect to get sued. If you have a use, socially useful and beneficial use for these things, then you have less exposure, but you still have to deal with people's expectations and your contractual restrictions. So the takeaways here: expect courts to adapt. I did some online research in the all feds and all states Westlaw case database, right? So that's all federal and all state cases, from the beginning of this country till now. Where chatbot does not appear. Okay, so that means that doesn't mean there hasn't been litigation regarding it, but there's no reported decisions that I was able to find. So, nevertheless, expect courts to adapt the existing legal doctrines to the use of chatbots. Courts have done it with other things. They did it with the internet, they did it with virtual worlds, they did it with social media applications. They're going to do it with this. And then finally, be careful out there. So, are there time for questions, or do I? Yeah, yes, sir.
Regarding the trademark dilution that you talked about in the example with Microsoft and the sweaters, it sounds like the way you described it that the first instance, the sweaters, doesn't necessarily cause dilution, and it's not until it becomes pretty prevalent that there's any dilution. So who gets penalized for that?
Well, actually, I created the wrong impression there. I mean, the theory is that if you let the first person and the next 1,000, that eventually this mark would be diluted. So if you did that, you could expect a letter from somebody, some lawyer saying, they wouldn't say they might say, you're going to create confusion in the minds of customers, but depending on how extreme an example it is, they might not be able to say that with a straight face. But for a famous mark, at the federal level, famous marks, I mean super marks like Ford, Coca-Cola, McDonald's, you have a federal cause of action. If it's a less than a famous mark, so Joe's Garage or whatever, there is state by state protection for dilution. Yes,
that was a big thing with the cyber squatting. Take up the squat names.
Yeah, well, cyber squatting is prohibited expressly in the Lanham Act. That's the federal act. And so cyber squatting refers to the appropriation of a domain name that contains a famous mark or a distinctive mark. And yes, that is treated as a trademark infringement. And word or two on that, there's a federal cyber squatting act that is part of the Lanham Act, or it's bolted on to the Lanham Act. And then there's also a system of private arbitration conducted by ICANN. So domain name, arbitration, so that if you're out there and you have a famous mark, Donald Trump one day wants to put up DonaldTrump.com, and he finds that 2 years ago somebody whose name isn't Donald Trump and has nothing to do with Donald Trump, registered DonaldTrump.com, he can institute an arbitration proceeding, and they will yank that domain name from that person if it's found that somebody was cyber squatting. So, or you can sue in federal court, which Donald will probably do.
You were talking about likeliness of a bot to a real person. So using your example of Einstein, back when Microsoft Office came out with these little assistants, they had one that looked like Einstein.
Right.
So they had a clicky on the Einstein. So at what point do you say, well, everyone looks at it and say, yeah, that looks like Einstein, but it's also a genius. So at what point do you really say it's Einstein and not Einstein?
Well, that would be to the extent that icon, I'm trying to remember back to that, looked whimsical, or was clearly a cartoonish figure, and they were playing on the bushy eyebrows and the all those things that evoke Einstein or evoke the mad professor or whatever they're trying to do with that icon. You would say that that's transformative, and so that artistic transformation, that element, is protected by the First Amendment of the United States Constitution. And, on a case-by-case basis, that's how courts are going to decide it. Likely, again, I don't know what the legal status of the use of his likeness is, but I would think you'd probably get away with that.
So, well, the question here is really more, it's impossible to say maybe today somebody can take my picture and animate it and make me look like me, or my mom said, oh my God, that's my son. Anything else is really a poor imitation of that. So whether it's a cartoon, whether it's a rendering of that person, it's never going to be lifelike. It's always going to be something that, we're talking computers here, so you can't get it right.
Right.
It will never be right. It will never be exact. So maybe recorded pieces of voice using the chatbot, that will be exact likeness.
Yeah.
But anything computer generated loses that immediately. It's always a satirical computer impression. There's always lostness there.
Yeah, I would. Right, the graphics aren't to the state where they're 100% carbon copy, but I would still, in figuring out, whether you launch something, with somebody's likeness, and it's still an issue because it's there have been cases where it's not a photo, but liability has been found.
Frank, I'm still struggling to understand the identification issue. I think if I understand what you're saying is that if I sell someone a bot and that bot, for example, quotes some copyrighted material, then the copyright owner could try to sue the customer in that case, and they would want us to identify them against that.
Yeah.
And then we can buy insurance that will protect us from that. But the follow-up question is, in our field, there are kind of spurious patents and patent trolls and that sort of thing. Can we suppose someone tried to sue our customer for patent infringement? Can we buy insurance to protect us against that?
I haven't taken a client out shopping for patent infringement insurance. I'm going to assume so. I would think that that might be more expensive. I've dealt with trademark and copyright infringement, so I would expect that somewhere somebody will write a policy for that. But depending on how settled or unsettled the area is, that would be an underwriting issue for them, and you might have to, if it's not a well settled field, perhaps you'd have to pay a premium for that. I mean, sometimes, and whether you go and do that is going to be driven by how much money you're making, a commercial reality. Because, what's scary about, software patents, which are maybe going the way of the just, based on where the Supreme Court jurisprudence is going. It's a lot harder to get software patents now. But yeah, it creates substantial uncertainty because you could be there and somebody comes out of the woodwork. So that's a risk that is imperfectly dealt with a lot of times, and sometimes it's just dealt with like, well, it's either the customer's nickel or it's your nickel. I mean, that's done by contract.
Okay, one more question.
What about using the likeness of public officials, like politicians, and their actual quotes? I think that's protected by fair use or First Amendment? Yeah,
there would be probably, the issue wouldn't be so much that they're a public figure, because I mean a lot of these cases involve public figures, and it would come down to, are you making commercial use, or is what you're doing transformative or not? I know in Pennsylvania, for example, there's an exception to the statute for the use of likenesses in newscasts. So the same analysis would apply. It's a senator or whatever. I mean, if you're trying to make money off the senator's likeness, there's potential liability there. Right, out of time.
Yes, sir.